That's called the case of the people versus Jermaine Johnson.
Assistant Public Defender Kelsey Reveals with and on behalf of Jermaine Johnson, please state your name.
Ryan Johnson.
Thank you. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that he is going to be pleading guilty to the charge of attempted resisting and obstructing the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement. The sentencing judge waiver is not checked, but that was reviewed with him.
Oh, I'm sorry. You understand you wouldn't be sentenced in front of Judge Simpson?
Yes.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name, please.
Jermaine Johnson.
All right. Sir, it is this court's understanding that you are going to be, well, hold on a second. Yeah, there's two cases, and I'm sorry, I didn't go through the other one. In the other matter, that being the case ending in 5805, he's going to be pleading to use of cocaine. That's a count 3, and counts 1 and 2 would be dismissed. And the sentencing judge waiver would also apply to that one. You understand that, sir?
Yes, I do.
That's Christian. All right. You've been sworn. Sir, I do.
Notice how the judge slows things down here. This isn't courtesy, it's protection. The court is building a record to prevent future appeals claiming confusion or coercion. Judges do this when they want the plea bulletproof.
On the one case, court believes you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
I understand, yes.
And on the other matter that you're going to plead to the charge of use of cocaine, that's also a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that?
Yes, I do.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentencing these matters before Judge Valvo, or her successor, which we kind of know now, but
I understand.
I'm not sure the dockets will stay that way, but you understand that, sir?
Yes, sir.
All right. Understanding that, you still wish to plead guilty to these charges?
Yes, I do.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of use of cocaine, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
I understand. Yes.
You signed or had cause to be signed an advice of rights form
Yes.
on your behalf. Is that correct? You have any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I understand. Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
This explanation isn't about innocence, it's about tone. Judges listen closely to how defendants explain themselves. Does it sound evasive, casual, honest? Ask yourself, does this answer help him or hurt him?
No.
You're doing this voluntarily
Volunteer.
of your own free will,
Sir.
and because you believe that you're guilty of this?
Yes.
Yeah. On the date, starting with the attempted resisting and obstructing on the date of November 24th, 2025, at the location of Las Vegas Drive near Palomar Drive in the city of Ypsilanti, or city of Ann Arbor, Washtenaw County, state of Michigan. Did you come into contact with police officers from the Ann Arbor Police Department?
Yes, sir.
What happened?
I rode off on my bike.
You what?
Rode off, tried to get away.
Did they give you an order to stop?
Oh, they told me to stop.
They told you to stop. You said, I'm not stopping, and just kept going.
I was thinking about Thanksgiving.
You were thinking about what?
I was trying to make it to Thanksgiving. I promise. Was
What day was Thanksgiving?
it 20? It was the 24th. Trying to make it to.
So 3 days before you were trying to make it to Thanksgiving, where were you going?
I was trying to make it home.
Okay. No,
I myself in.
Oh, gotcha.
Eventually.
I see what you're saying. That didn't work out, did it?
No, it didn't.
Yeah, it didn't. Okay. And you knew that they had given you a lawful command at that
Yes.
point, and you disobeyed it.
Yes.
All right. The other case. These would be uniform, there wouldn't be a problem. I'm not gonna worry about it, we'll just find it in. Seriously, people. On the date of June 4th, 2025, at the Packard Road near Platt Road.
Once a plea is accepted, there's no rewind button, no trial, no jury, no second narrative. From this moment forward, everything shifts to sentencing, and that's a whole different battlefield.
City of Ann Arbor, Washington County, State of Michigan. Did you have cocaine in your possession?
Yes, I do.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
All right. Sir, I do have to advise you that if I accept your plea, between the time that I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not, first of all, not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I understand.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty in each of these cases to count 3, counts 1 and 2. I think the both matters are dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be.
Past behavior matters, especially when bond or release is requested. Courts remember flight risk, missed court dates, and warrants. So, here's the question for you. Should treatment ever override a history of running from the system? Drop your take in the comments.
Third at 9 a.m. For Belleville.
February 3rd, 2026, 9 a.m. And it's before Judge Valvo in each of these cases. On will continue. He has I did, so that you're aware, I don't know if it was sent to you. They requested that he be released to treatment. I approved that on his cases. So he might go to treatment. That was something through the sheriff's department that they sent us.
Would Your Honor consider, in light of the plea, a personal bond today and then allowing him to, of his own volition, seek treatment?
You really want to go back through the warrants where we had to find him?
Oh, you're not gonna have to find me.
Well,
We
Yeah,
do
no,
have his
fine.
current address. We know where he would be located.
I should have just let it go. What I was trying to tell you is I've signed an order to release to treatment.
Oh, yeah, that's fine too.
And that was sent through the jail process as opposed to, and I've approved his release to treatment. If you'd like him released on a PR bond, you can take that up with Judge Valvo's successor or whoever's handling it. I'm not going to change it at this point.
I understand.
All right?
Thank you, Your Honor.
Thank you, sir. Good luck to you.
You have to fill out his packet.
Okay.
Court does call the case of the people versus John Brown.
Brian Bowling on behalf of Mr. Brown. State your name for the record, please.
John Brown, how you doing, Your Honor?
I'm doing okay. I may be.
Judge,
Go ahead.
for purposes of the probable cause conference, I'm asking for an adjournment so that we can review the video from the incident with Mr. Brown.
You have his violation.
I do. I'm aware of it. Mr. Brown and I have spoken about it, Your Honor.
Okay.
Your Honor.
Want to deal with that? I'll give you the adjournment.
Yeah. Ultimately, Your Honor, Mr. Brown, I would advise you against saying anything.
Well, I just wanted to speak on the violations.
I was going to speak on the violation, but you're welcome to do it if you'd like to.
Honestly, Your Honor, it was on a violation. It was a misunderstanding. When I went over there to drop, and then she called me back for a phone interview. I asked her what was the next, and she said that would be up to the judge. So 3 days later, I spoke to Alexis, my old lawyer, while I was at work, and
Your Honor, may I say something on Mr. Brown's behalf with respect to the violation? Judge, he would missing those tests on November 13th and December 18th. However, he did report to kindergarten and tested out on the 3rd. He's currently on,
And was positive for THC. You got a medical marijuana card?
he does not judge. He indicates to me that he's on probation with Judge Slay. To my understanding, that's going very well. He did surrender himself on this matter to address this case. He does want to comply with this court's bond conditions. He wants to test as ordered.
Then why didn't he go?
Well, he did go originally, Your Honor, but
Went and he's positive for a drug he cannot by court order. So
Granted.
then we don't see him again.
Well, like I said, he is on probation. There is an order with that court and that status to test. I do believe Mr. Brown, and we spoke last night after receiving this report, where there was a misunderstanding with his discussion with Ms. Dozier that the testing that he was doing on probation would be satisfactory for the purposes of bond. That turns out that was his understanding. That's not accurate, Judge.
Is that where the case? Why did he go on the 3rd?
Because that was the initial intake. That was the initial test. So if the court would allow him to go over to community corrections now, he could get testing established and he would continue testing. I cleared it up with Mr. Brown when I talked to him last night and today. I
still doesn't have a card. Is marijuana going to show up in your system?
It will, Judge.
A little bit will.
A little bit?
Yeah, I don't know how the levels go.
Just a little bit of weed.
Cause I don't know how the levels go on New Year's Eve. I don't drink, so I did.
So
I did eat an edible.
Smoking what you got.
I mean, I'm not gonna lie to you. I mean,
No, I don't want you to lie to me. I'm just saying you're on bond.
yeah. And I didn't even I was up until I spoke to him yesterday. I was unaware that it was even illegal to smoke marijuana because it's legal. So it really was a misunderstanding, Your Honor. I'm asking you not to lock me up for it. Right now, I'm working. I got a full-time job. I really can't afford to lose no days right now.
Should have gone to testing. What I'll do is I'll only set it out 1 week to the 15th. But you guys try to figure that out and maybe give me the testing that he's doing on his other matter in circuit court. But at this time, the defendant's bonds revoked.
Thank you, Judge.
Court does call the case, People versus Sandra Law. She's coming. Law, do they have? I don't even know what file it goes in, right? Your name, ma'am?
Sandra Law.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Law. State your name.
Sandra Law.
Sorry, here's a scanner for you.
Stephanie Kane on behalf of Ms. Law.
Really? Why are you late?
I know reason. I'm sorry, Your Honor.
All right.
Sorry. We're going to ask for an adjournment on this matter, Your Honor, while we negotiate in this case. I would like to address bond.
Again?
Yes, Your
Is there
Honor.
gonna be anything different than I heard the last 2 times
She just-
that I denied her bond?
Well, Your Honor, she's been in for almost 70 days now, not quite. I think it was like 67 days when I checked. And they're not releasing her to treatment. There's nothing keeping her but your case. My client absolutely does. I'm sorry, I'm a little bit out of breath.
Said
now.
that, the only, like, I'm to blame.
No, yeah, I mean, no.
Are you, no, okay, all right, okay.
Judge Washington gave.
No, Cannon, you're doing really well, go right ahead.
No, because Judge
Like
Washington
me.
gave her a PR bond, so the only case that doesn't have a PR bond with release to the house is yours, is what I meant by that, Your Honor. Yours turning red, because I feel like I'm turning red. And so, Your Honor, again, my client, she does want to go to treatment. We're requesting that she goes to treatment. If you tether her to her home, she will go to outpatient treatment. We've done the
What
process
would
here.
change my decision from the last 2 times that you've argued this? Just give me those.
Well, Your Honor, I believe that the court wants her to be in treatment as well because this case is a drug-based case. She had been sober for a full year. She had been doing her drops, her testing in Judge Washington's, which is why Judge Washington let her go. She came back, she had COVID, she got really, really sick. And then her grandmother passed away, and she acknowledges that in that moment, she made a bad decision, one that she regrets deeply, one that she regrets very, very much so. And she just
I've
has.
seen the movie Groundhog Day.
I have, Your Honor.
Yeah.
I really have. It's a
And
great
it's like
movie.
it just repeats and repeats and like,
My client asked me to ask you to
know.
please reconsider, Your
and
Honor.
I want her in treatment. I really don't want to hold her.
I understand.
But, and that's why I said, treatment, great. But do I trust and will I release her on a straight PR? At this point, I will not.
And Your Honor, thank you.
Can I speak, Your Honor, for a minute, please? I wrote you a letter and I signed up for schooling to start January 5th for psychology. And I do have a job and they only hold it for me till February. And I do have a house, which you know the situation, and we have a court date tomorrow with you with the Sturman Serenity and the Thomas Berry case. And I please ask you, because Judge Washington did want me to go to treatment and I've been in her court with her since 2023. And I promise you, I will get into intensive outpatient treatment. I promise you, you will have no dirty drops. I will drop 2-3 times a week for you. I don't want to lose my schooling, my house, my job. I've worked so hard for 2 years to get sober and work with Judge Washington. I promise you, she's put me on house arrest tether, not a GPS. So I could only go to work for my 3 months of probation. I promise you, I will do your court with flying colors if you please PR upon me to go home so I don't lose everything I worked so hard for. I wrote you a letter, Your Honor, pleading and begging you to please. I don't want to lose everything. I don't want to have a gap and go backwards in life. I've been an addict for 15 years and it took me 2 years to get where I am today for one relapse over a death in the family that I've beat myself up over. I've went to my doctor. I've cried to him. He had put me on a cocaine blocker called Topamax. So if I ever came across a situation like this again, where I've had a damper in life, I would have the blocker to stop me from using. It was a one-time relapse. And like Miss Washington said, the old Sandra would have tried to beat the test, beat the system, just not dropped and missed the test. And she was proud of me that I didn't try to beat the system and took responsibility of my dirty drop. And I did. I didn't try to do anything to beat it. I didn't try to, I just, please, I beg you, you'll not have to ever put me in jail for a dirty drop again. I promise you that on everything I love. I don't want to lose what I've worked so hard for. It's been a struggle for me since 2023, working with her to get this far. And, I was already on the tether, set to go to treatment the day I had court with her. And that's what stopped me from going, because she was going to put me into a long-term treatment. But then when she realized and evaluated the case, she said, no, I'm not going to do that to you, Ms. Law, because she knows the struggle I had and how long it took me and how hard I worked to get where I was. And I can't say anything but to please give me that chance. I've never been in front of you, and I promise you, you'll never have to ever worry about me being in front of you for a dirty drop again. That's all I can say, Your Honor, please.
I'll adjourn this matter to January 22nd, 2026, 9 a.m.
Thank you, Your Honor.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Days, People versus Amaya Campbell.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Campbell,
Oh, there she is.
She's here
Hi,
by.
good morning, Your Honor.
I'm doing well. Your name?
Amaya Campbell.
Thank you. You're requesting an adjournment on this.
Yes, Your Honor, there's some video we need to get a look at. I thank Mr. Childers for requesting it.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Court calls case of the people versus, oh, there. Versus Melvin Lilly.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Lilly, who's what you know. Mr. Lilly, will you state your name for the record?
Melvin Lilly.
Thank you. I'm asking for an adjournment. I did reach out to the prosecutor's office for consideration for a reduction. They're reaching out to the officers.
Probable cause conference, then January 22nd, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls case of the people versus Gerald Casanova.
Assistant Public Defender Chelsea Reveals on behalf of Gerald Casanova. I haven't had contact.
Haven't had. Casanova. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. Cash surety. That warrant will issue immediately. Court calls case of the people versus Chalice McLaughlin.
Anna Mackey on behalf of Mr. Chalice McLaughlin.
All right, what do we do?
Your Honor, we're waiving. I believe there was a traditional waiver done already, but
Okay, record should reflect you had a bench conference in this case. And we're going to adjourn this matter out just 1 week to try to determine what happened prior to the waiver of jurisdiction in this case, because that will dictate what will happen here. So I'm adjourning this to the 15th, 2026, 9 a.m. Bond will continue. Thank you.
thank you.
Court calls case people versus Wesley Brand. Wesley Brand
Is he not in Washington County Jail?
not on yet. He's in custody, but
Yeah. It's not.
I'll pass that.
It's gonna be just a couple minutes on Brand. I'm starting to make my way down there. If you can just give me a couple.
Okay, all right. We'll wait. Turn on the camera. We'll call you back. Court does call the case people versus Donovan Smith.
On behalf of Donovan Smith. Donovan, would you state your name for the record? Would you just state your name for the record?
Donovan Smith.
Thank you.
Judge, this is a situation we're at. I was just appointed on this case. This is his second case. His first case about a month ago, we bound over to circuit court. To Judge Kuhnke, there was an argument of what had happened. Long story short, Judge Kuhnke yesterday ordered that the case be remanded back down to district court for a preliminary exam. And
on what theory?
Well, Judge, this case and the original case, both had the same offense dates, were hours apart. It was our argument that they should have been bound over. We should have known them together for what that's worth. And so long story short, I got a note from Judge Kuhnke's office that they were remanding the case back for the 15th. So I was going to ask for a 1-week adjournment and get these matters.
Had the other case already heard an exam?
No, we waived the exam, Judge, on the condition that the bond was lowered, which it was by you, from 50,000 to 10%. And then once we got up to circuit court, we found out about this case, which was the exact same day, only hours apart. And our argument was that we should have known about both cases.
Okay.
So all I'm asking is, Judge, if I know my client wants to have an exam in this matter, I don't have the police report, but that's fine. If he wants to set an exam, we can set an exam. But I was told by the Judge Kuhnke's court, the case would be set for the 15th. I don't know if that's true or not. I guess what I'm asking for, Judge, is I know this is a very impatient man, set matters for the a week from today.
May I speak?
Go ahead.
First, I don't know if you remember me or not, but I've been in here.
I remember everybody.
I adjourned like 6 times.
No, I
And then my lawyer made a deal with the prosecutor. They'll 10% my bond and they can't add no new charges if
I remember, well, I don't know that no new charges were. I remember
he
it
told me
was,
that
just listen.
Okay.
I'm telling you what I remember specifically about it, because it's unusual for me to even agree to it, was that you were going to waive up and I reduced your bond. All right, that I do recall.
That case was a discharge of a building, so it was our impression that
Right.
they weren't going to add any firearm charges to that, any additional charges. I did not know about a second case where he was allegedly caught in a car with a gun. So now this charge is CCW. I can understand his frustration, but there are 2 different cases at the same exact day.
Yeah.
I never got arrested with a gun. They never.
Sir, I don't want to talk about the facts of it. I'm just procedurally trying to figure out why in the heck we're where we are. The case waived up, right?
Correct.
I reduced his bond. Did he get out? Did you get
He
out?
tried, that very day, they charged him the second day. He never got a chance. He was arraigned a $25,000 bond on this case, which prevented his release on the first case. He never made it out, Judge. He was about ready.
So there was an agreement that he'd waive up. I reduced the bond. They didn't charge a new case and he's held.
Correct.
That's beautiful.
So what we were asking today on this case, if it would be $25,000, 10%, I don't believe the prosecutor has an objection to that. Hopefully, both matters can be heard next week and this young man.
Well, I don't even know. Here's the problem. And I don't have a problem with that, Mr. Killawall. The problem that I have is something's coming back from circuit court. It's supposedly set for the 15th. I don't know that. And usually, if something is going to be set on this docket, we get a call. Somebody tells us, because we'll give them the date. And so what I'm a little bit worried about is I'm going to adjourn this young man's case out next week, and I still don't have that other case.
I think I can't say for sure, but it sounds to me like the circuit court.
I don't know why that's coming back to us. I don't get that. And I'm not saying that anything you're telling me is not what you know. I don't know why it's coming back, and you're telling me there's this case coming back. He's got this case. I remember what I did when I released him on the other case. And now he's back in, and you want me to give a date that I don't know who's going to be able to go for. I mean, none of this is making much sense to me.
I think this young man thought that there would be no new charges.
Well, whether or not there are new charges or not, I don't know that is necessarily my issue right now. My issue right now is I'm trying to get his case heard. And this case that's in front of me right now, I can't even get that heard because now you're telling me there's this other mythical case coming back to, I don't know. And it's on the same date. Do we have anything?
Listen to me. 1 week. No. You don't understand what I'm saying.
No. Here's the thing. If I adjourn it out, well, you guys have your conversation. I'll just wait.
Judge, I'm sorry. I understand his frustration, but I don't have.
Well, yeah, I understand his frustration too, because he waived up. I reduced his bond. New charges come. He then gets he then can't go. And then when the case goes up, regardless of what his understanding was and what that was, now all of a sudden it's going to come back. Meanwhile, while all that's happening, I'm in custody. So, I don't know why he's frustrated. Because as you can tell, I'm not. Okay, but here's what I'm going to do, okay? You may not like the answer that I get, But at least what I'm gonna do is I'm gonna get an answer. So we know what to do. Okay, because I don't want to set it for next week. And next thing I know, that case coming from circuit is 2 weeks out, because then I gotta bring him back again. That doesn't even make any sense to me. So
Today,
say nothing.
Judge,
Say nothing.
as far as bond,
Say nothing.
you're very considerate, Judge. Judge, I think, would you?
What?
What's the probable cause for this case?
Fine.
Please ask that.
Here's what I'm gonna do. I'm gonna pass the matter, take him back. I'm gonna call down, or my staff call down. We're gonna figure out where this man's case is at, where everything is, and try to get it all where it's supposed to be.
All right, thank you.
And nobody may like the decision I make in the end, but at least we'll know what's happening, because right now, we don't even know what's happening. You understand me?
Yeah.
Say nothing. Take him back. Court calls the case, People versus Donovan Smith. No, that was the same case. Why are you doing it? Just. Is this the one? It is. Court calls the case, People versus Wesley Brand. Why'd you take those other ones?
And Maggie, on behalf of Mr. Brand.
Mr. Brand, can you state your name for me?
Wesley Brand.
Thank you. You're requesting an adjournment.
I am, Your Honor.
You got to get the discovery. Probable cause conference will be adjourned to January 22nd, 2026, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Mark Copeland.
Hannah Mackey on behalf of Mr. Copeland. Who is, Mr. Copeland?
What are you doing to Lebo look? Are they here or not?
In the hallway?
You know what the Lebo look is?
Pardon?
You know what the Lebo look is?
The what look?
Lebo look.
No.
Lebo gets up here all the time. I call the case. He doesn't know if his client's here, but he looks through the door expecting some miracle. So I expect that's what you're doing.
How did I get involved?
You're the cause of it.
I tried to get a hold of Mr. Copeland. His phone number was invalid and his email was also invalid. We're respectfully requesting to adjourn this matter so I could attempt to get a hold of him.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately.
Thank you.
Court calls the case People versus Latricia Mopkin.
Hannah Mackey on behalf of Mrs. Mopkin, who's approaching.
No, look this way, ma'am. Come on up. Your name?
Latricia Mopkin.
Thank you.
Your Honor, requesting to set this matter for preliminary examination. And all discovery is complete as far as we are aware.
Would the people have their witnesses available the 20th? Preliminary examination in person will be set January 20th, 2026, 9 a.m. before Judge Fresh Hour.
May I just bond, Your Honor?
You may.
Ms. Latricia, she works at U of M as a housekeeper. Currently, she's on non-paid leave. However, that's temporary and she could permanently lose her job there. She has 4 kids and one of them, Ms. Latricia is the sole provider for her kids. Her family is here today in court as well, and she has a place to stay with them upon release. So we're asking for Ms. Latricia to be released, and she is okay with complying with GPS tether or any other conditions the court finds necessary.
Responsible.
Your Honor, at this point, I'm going to object. This is an extremely serious case in which the victim was attacked with a hammer in which she was hit in the head several times with that hammer. there was a struggle then for that hammer, and then during that struggle, he was then stabbed in his stomach. So given the severity of this case and the injuries that he sustained, I'm gonna object at this time to any modification of bond.
And Your Honor, we are presenting this case as a self-defense, and Miss Latricia would not be staying at that address upon release. She would be staying with her daughters, looking after her.
I mean, typically the self-defense isn't, I mean, are you indicating that the alleged victim possessed some weapon at some point?
I believe there was some form of altercation.
Well, an altercation is one thing. Are you saying that a weapon was possessed? Because that might factor into the court's decision, but if that's not what's being said, then I'm not sure that true self-defense is going to apply in any event, although I'm not trying to make that analysis.
There was no actual weapon.
Do this. There's the allegation that there are two weapons that would be used by this defendant.
He did have a knife, Your Honor.
Okay, then you can certainly address that even, while I'll factor that in, I still don't think bond would be appropriate or a reduction in bond would be appropriate in this case. I'm going to deny your request. Certainly you may raise that after the preliminary examination on the 20th before it gets fresh out.
Thank you, Your Honor.
Thank you. Looks good. Guys want to walk around? Young lady? No, come here. Come here. Oh, boy. Get her, Mr. Allen.
Who is that? Who was that?
All right, I'm gonna step off. If she brings him in, just throw her in the box over here or cuff her, put her wherever. Hey, lady, what's your name?
Sequoia Jones.
What?
Sequoia Jones.
Why were you causing a disruption in the court and then
I
didn't
was
come
talking
back?
to my mom's lawyer and he stood up. I wasn't talking to him. I didn't say nothing to him. I was talking.
Why didn't you then stop when I told you to stop?
I apologize.
That doesn't work that way.
Your Honor,
You want to be represented by counsel, ma'am, because you disrupted these entire proceedings. You want an attorney?
Yeah.
The PD can handle this, I think. She can go back into custody. I'm gonna take a brief recess and then I'll bring her back out. We'll deal with it.
All right.
There's an in custody down 12. Okay, thank you.
Court calls the case of the People versus Earl Covington.
Rock out assistant prosecuting attorney on behalf of the people.
Assistant Public Defender Davey Lebo on behalf of Mr. Covington. I don't think it's a Lebo look if he's walking in.
Come on.
Could you state your name, sir?
Earl Covington. Thank you, sir.
And you're going to be requesting adjournment today in order to continue some discussions as well as get some additional information.
Probable cause conference, I'll set it for January 29, 2026, 9 a.m. Or as your invite indicates.
Thank you.
And will continue. Thank you, sir. He's a Jim. Court does call the case People versus Dontrell Smith.
Dontrell Smith. Your Honor, Mr. Pillwall had to go back to his office real quick so he could pass that.
This is not Mr.
Oh, sorry.
I'm ready to go. Mr. Smith is in custody, Judge.
Pardon? I don't have it.
Brian Bowling on behalf of Mr. Smith, he's in
Are
custody.
they not respond? Yeah. He's,
They're not responding.
they don't have Smith.
Smith is in Zoom. They have turned off their.
I know. But now the camera's on.
You ready for Smith, Your Honor?
Yes, yes, sir.
All right, we'll get him.
Hey, Smith, come on. You ready?
Guys, call the case of the people versus Dontrell Smith.
Brian Bowling on behalf of Mr. Smith. Mr. Smith, can you state your name, please, sir?
Can you tell us your name, Mr. Smith?
Dontrell Smith.
All right, thank you.
I'm asking for an exam, Judge. I believe all discovery to be complete.
People have their witnesses available the 20th. Preliminary examination will be set in person, January 20th. Is that right?
Yes.
2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Brandon Myers.
Glenn appearing on behalf of Mr. Myers. Can you please state your name for the record?
Brandon Myers.
Thank you, sir. All right, what are we doing?
We would like to request an adjournment, and when appropriate, I'd like to address bond.
Of the, do I have a green sheet? No.
Oh, yes. I will.
Probable cause conference in these matters will be adjourned to January 22nd, 2025, 9 a.m. All right. Yes.
Okay. Your Honor, we are requesting that Mr. Myers be released on a PR bond with a tether to his grandmother's house. I'm sorry, to his mother's
My
house.
mother's in the courtroom too.
She has a lot of health needs, and she has,
Is this the same motion that I already denied?
I've never done a motion.
Oh, yes, you did. The motion on this, a motion to modify his bond, which I denied on December 11th. But go ahead.
Is that enough? She's in the courtroom?
Yeah. He wants to let you know again that his mother is present today. She has a lot of health issues, including her vision is severely impaired. And Mr. Myers is her support system. He takes care of the house. He helps his mother get to and from her medical appointments. He has a strong tie to the community. He has a positive support system, which includes 3 of his family members are here today. And
I went to school with her.
he also states that you went to school with his mother as well.
Pardon?
You went to school with my mother.
I did?
You seen me in 2008 and you said you did know my mother. She's right there, the light skinned lady.
The light skinned lady? Really? Which one do you want me to pick out?
The one that's laughing right there.
Okay.
Her right there.
Hello. Okay.
Okay. Your Honor, we believe tethering him to the house would keep him from interacting with the complaining witness. And he is well aware of the PPO and in this court's direction to have no contact with the complaining witness.
You know I don't play with him either. I don't play with you either. You know that.
What?
No, I don't give you no hard time either. I do what you do.
People can give me a hard time. When you go back, you can ask that young lady. Is there a response from the people?
Your Honor, since this motion was already brought about a month ago, we asked the court to repeat denying it and just highlight the facts where the defendant is reported to have come to the victim's house, threatening to kill someone if he sees. Also showing up at the victim's church, creating an influence where he also.
That's a lie.
That safety of the public is necessary, and that bond should be continued.
I ain't threatening nobody.
All right. I've already heard the motion and ruled. I don't hear anything different. If maybe there's a conversation had with the prosecutor and there are certain conditions that will alleviate their concerns, then maybe the parties can stipulate to something, but I'm not at this point gonna change the bond or the court's decision. The motion for bond reduction is denied.
Thank you, Your Honor.
Court calls the cases of the People versus Bernard Lee Fonville. 6 cases.
Mr. Bonville, will you state your name for the record?
No, Fonville.
Thank you.
Thank you.
Your Honor, we're asking for an adjournment to review discovery with Mr. Fonville.
Is it extensive or is it?
No, no, there's just 6 files to review, so.
Yeah,
just
that's what.
A couple weeks. I provided him a copy of the discovery today, so.
Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
29th. Take care.
Court calls case People versus Johnny Charles Payne.
Michael Gaddy, Assistant Public Defender. Payne is approaching
Your name, sir?
Johnny Payne, sorry.
Thank you.
Yes, Your Honor, I've had a chance to speak with Mr. Payne and with Mr. Cook. Your Honor, I'd ask Mr. Payne has a parole hold I need to investigate. We were going to set this date, for example, but I'd ask the court to adjourn it so that I can continue trying to reach his parole officer.
The 22nd or 29th?
The 29th would be good, Judge.
Probable cause conference January 29th, 2026, 9 a.m. Bond continue.
Thank you.
Court calls the case of the People versus Carlton Cross.
Thank you.
Assistant Public Defender Davi Leba on behalf of Mr. Cross.
Hello. Hello, what's your name?
My name is Carlton Dion Cross.
Thank you. You're
Thank you,
asking for
sir.
an adjournment for additional discussion.
I am, Your Honor. Thank
Probable
you.
cause conference January 29th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, sir.
Thank you, Judge. Thank you.
Calls case People versus Adam Perella.
Assistant Public Defender Davi Leba on behalf of Mr. Perala. Could you state your name?
Adam David Perella.
Thank you.
And Your Honor, we would like to set this matter for preliminary examination, please.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 20th. Preliminary examination in person, January 20th, 2026. Sorry. 9 a.m. It's gonna take me a minute before Judge Fresh Hour.
Thank you, Your Honor.
Bond continue. Thank you. Court calls case of People versus Zakara Daphne Bursiaga.
I expected this to be called when you took that pause, Judge. So,
Yeah,
Brian Bowling on behalf of Ms. Daphne Bursiaga, Your Honor, can you state your name for the record?
Zakara Daphne Bursiaga.
Exactly what I said. I'm pretty proud of me. Go ahead.
Your Honor, we're asking for an adjournment for ongoing plea discussions in this matter.
Okay. What? Council Roach. No, this is. Let's do February 5th, 2026, 9 a.m.
Thank you, Your Honor.
You're welcome. Bond continue. Court calls case of the People versus Jack Saunders.
and on behalf of people.
Stephanie Cannon on behalf of Mr. Saunders, who's approaching. Mr. Saunders, could you please state your name for the record?
Jack Lee Saunders.
Your Honor, we are asking for a 2-week adjournment in this case for plea negotiation purposes.
Without objection, January 22nd, 2026, 9 a.m. Bond continued.
And Your Honor, there is a violation.
Is there?
It's my understanding.
Our violation was brought at trying to go to.
Yes, basically, yes. And there's, well, it says a lot of stuff.
Here's a bond violation, no bond.
Yes, Your Honor. So we are going to ask for a hearing as to the violation. My client had double pneumonia, and so for a chunk of this, he was just in the hospital. And so we
Does
got to
he
get.
have proof of that?
We're getting release of information for University of Michigan and for Trinity.
Then I'll
So
set
when
it
I
for the
spoke with
22nd at 3 p.m.
122, Your
And
Honor.
then I'll set a hearing on bond violations at that same time.
Thank you, Your Honor. Perfect.
At this point, his bond will continue. Thank you. Our call's case, People versus Juan Daniels.
And Mackie on behalf of Mr. Daniels,
Your name, sir? Juan Daniels. Thank you.
Your Honor, requesting to adjourn this matter.
What is it with you and the green sheets? What is the issue? You know the routine.
It's been a while, I think. It's been a whole year since I last seen you.
No, that was last year. That was not a whole year. That was good though. Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continuing.
Thank you, Your Honor.
Thank you. For calls cases of the People versus Kirby Snyder.
Chavalowski, people.
Two.
Veronica Glenn on behalf of Ms. Snyder. Please state your name for the record.
Kirby
please.
Snyder.
Your Honor, we would like to request a 1-week adjournment.
Why 1 week?
We need time to get discovery.
Is there anything else holding her? Because I'd give her 2 weeks, but 1 week is really for emerging circumstances. Nothing else is holding. We don't know why you asked for 1 week. Cannon sent you up here to say, do 1 week because you know that'll irritate him.
We need discovery. That's all I have.
That's all you have?
All I
They
have.
just sent you out there, threw you to the wolves. They need to treat you better. I'll adjourn it 1 week because you asked. There might be a reason. Oh, no. January 15th, 2026, 9 a.m. And because you at least have your green sheet, Ms. Mackey.
Thank you.
I don't even know what cases, if she do it.
One's right before this one.
Yeah, I know, but I don't even know if we have the file. Court does call the case, People versus David Davenport.
Good morning, Your Honor. People.
Glenn on behalf of Mr. Davenport, can you please state your name for the record, please?
David Davenport.
Thank you.
Your Honor, we would like to set this for a preliminary exam.
All right, discovery is complete.
Yes.
Oh,
Your Honor, I don't believe discovery is complete. I discussed earlier, originally we're going to set for exam, but I thought we discussed a second time we were going to adjourn for that discovery. It's not that.
Your Honor, Stephanie Cannon on behalf of Mr.
so
Davenport.
you didn't give the information to Ms. Glenn? No,
I did
that's
not,
a
Your
yes or no response. Don't worry
I-
about it. You're not in trouble.
That is correct. Your
What?
Honor.
That's a yes or no, right?
Yes, it is.
You did not give the information to Ms. Glenn, and so she took the instructions as she had them,
Yes.
correct?
That is correct.
Okay, now that we know that you have fallen down on the job and that there is needing to be an adjournment, you can sit down.
Yes, no.
No,
still
I
can't
don't need
sit
to hear
down.
from you. Sit down.
Still can't.
Sit down. I don't need to hear from you. I'm only gonna hear from Ms. Glenn. Don't try to whisper in her ear what to do. I'm gonna adjourn your case out till they get all the discovery.
Okay, Your Honor, we would like to request an adjournment. We also would like to make a request to allow him to return home.
Probable cause conference will be adjourned. Well, where's home?
Where's home, Mr. Davis?
Ann Arbor,
Ann Arbor?
3310 Fernwood Avenue.
Oh, he wants to return to his home address.
Yes.
It's not like, you made it sound like he lived in another state. I'm like, what state is he? Where is he? Okay.
And Your Honor, people were able to confirm with the victim that they are no longer living there, so I would have no objection to allowing him to return home and lifting the no-go too.
Motion for modification of bond in terms of the no-go to. Granted, because of Ms. Glenn's wonderful argument that was made.
Thank you.
So you may return, the no-go to will be lifted on that. And I will adjourn, given that, I'll adjourn this matter out January 29th, 2026, 9 a.m. as your invite indicates, bond will continue. Thank you, sir.
Thank you, Your Honor.
Thank you for your patience with Ms. Cannon. Court calls the case, People versus Alicia Whitberg.
Assistant Public Defender Jay Bellinger, on behalf of Ms. Wittenberg, who approaches Your Honor. Can you state your name for the record, please?
Alicia Wittenberg.
In Your Honor, 28 days ago, I submitted a 14B recovery court referral.
Yeah.
I have only today, after emailing them 7 or 8 times, have I heard back from them. So unfortunately, she hasn't even been processed yet. When I spoke with Mr. Reyes from that court, he advised that he didn't even know that she was in custody. So that as well as the fact that you submitted, you signed an order for her release to treatment. I've tried to be in contact with Sarah Stewart, who is handling her case. I submitted that on day 1 as well when she went into custody. Sarah Stewart still hasn't gotten back to me. It's been 7 or 8 times that I've contacted her. Ms. Wittenberg has been in for the last 28 days. As I stated, she was in on a bond violation. Your Honor, at this point, I do need to adjourn her case for the processing of the 14B recovery court referral. However, I am going to again renew my request for her release. She is working in intensive outpatient therapy with U of M. She has submitted that to the court prior as evidence. I want her to be able to be processed in one way, shape, or form as soon as possible through no fault of her own, as she's just sat in jail.
Well, yeah, I know. And my concern is, I realize there are delays trying to get people into treatment. There are 2 avenues here where something should have happened and
Correct.
Has.
Yes.
That concerns me. Not yet, if any. And I would prefer, quite frankly, if there's going to be a process where she can get into a recovery court, that's going to be the best shot for her, right?
Certainly.
So
Mr. Reyes did advise, because he didn't know that she was out of custody, that he could, if she were to get out of custody, he could give her a call and set up an appointment by Friday.
In custody?
If she's in custody, he said he would need to set up an appointment with her that they still haven't unfortunately done.
We're gonna turn her out to the 22nd, 2026 at 9. At this point, I'm going to continue her bond. I will consider something different if she's not, if we're in the same boat on the 22nd. I will certainly look at some way to do this differently so that she can get assessed. She's just waiting. I don't think she should have to. I get if there's not placement. I get if decisions aren't made, but at least it's a preliminary part of assessing. We need to be able to get that done.
Yeah, I know that she stands to lose a lot, including her job, Your Honor, and I know that she wanted to speak to that aspect of it. I don't know. I know you've already made your ruling, Your Honor, but
what do you want to tell me, Rhea?
The only thing I was gonna say is I do have good private insurance and that's, I have called myself and was told that I could get in under my own private insurance, but unfortunately, because I'm in here, I can't. If I was out, I'm just feeling like it could be faster than
Here's
waiting.
what I'll do. I'm gonna set it for the 15th. Somebody needs to do that. Mr. Manager, if what she's indicating, get me some information that says that she can't do it while she's in custody, and then I'll reconsider everything, but I'll just put it out 1 week for him to get that. We'll take a look at it. Fair enough?
Yes, thank you.
You're welcome. Thank you. Court calls case People versus David DeLucia.
Assistant Public Defender Chelsea Regiles with and on behalf of David DeLucia. Please state your name.
David Mark DeLucia.
Right, I've up every close. Is
Your Honor, he will waive his right to a preliminary exam.
that correct, sir?
Yes.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
I understand, yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over circuit court on both counts.
We acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial will be set for March 4th, 2026, 1:30 before Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. Does call the case, People versus Antonio Williams.
Good morning, Your Honor. Raymond Cook for the people.
Hey, sir. Thank you. You're requesting an adjournment?
Oh, yeah, well, Your Honor, this is a time for a competency review.
Yes.
I don't think we're near the 15-month period. I think it's a 10-year max on this matter. We did contact the forensic center. They said they met with Mr. Williams on the 18th of December, but they haven't completed the report yet.
Got it.
I wasn't able to get a date as to when it would be done.
All right, why don't I do this? Because we can always move up to date. Why don't I comp review? I'll adjourn it out to, I don't want to go that far, but I'm going to go February 26th. If we get a report, we can certainly move his case up.
Thank you, Your Honor.
9 a.m. Bond continued. Thank you.
Your Honor.
Yeah. Is he talking?
Yes, he was. I think he had a question.
Did you want to say something to me, Mr. Williams?
Yes.
What do you want to tell me, sir?
I need to wait to make a phone call. They won't let me make a phone call without money on.
To tell what?
They won't let me make a phone call without money on.
Oh, okay. And
nobody knows I'm in.
So there's somebody that you want to call to let them know that you're in?
Yes.
Okay, so here's
I've
what,
been here 6-7 months and nobody knows.
okay, and you know the phone numbers of the people?
No, I don't.
Okay,
I
so,
know what, it's the Elk Swim Club Card Club.
okay, so here's what I'm gonna tell you to do, Mr. Williams. I think what you should do is give a list to your attorneys as to who you want to have contacted to let them know that you're in, and let your attorneys follow through on that for you, okay?
Will they do it?
Will they do it? Is that what you're asking?
Yes.
I would suspect that they would. If they believe that it's in
Okay.
your interest, they will do their best.
They haven't in the past.
Your Honor, this is a matter that Mr. Williams and I did speak about yesterday.
Oh, you've already talked about it.
Yes.
Okay, all right. Then let them take care of it. And then if they don't, then you can let me know in February, okay?
Or I could bond out of jail if I could get to this.
To these people you might be able to bond out,
Yeah, I would.
then certainly your attorneys are gonna do everything they possibly can. I can tell you that for sure. Okay?
Thank you.
Thank you. Court calls the case, People versus Robert Dolan.
Andrew Children, on behalf of the people.
Just bear with that.
Mr. Lebo, where is he? This is you, we have you on this case.
Oh, is this Mr. Dolan?
Dolan. It is.
Apologies, Your Honor, I didn't quite hear the case name.
All right.
Assistant Public Defender Davy Leba on behalf of Mr. Dolan. Mr. Dolan, can you tell the court your name?
Thank you.
And Your Honor, we did receive some media on this case. I'm going to need some time to review, so I'd ask for perhaps a 2-week adjournment.
Pardon?
We have some media that would need some time to review, so I'd ask for a couple weeks adjournment, please.
January 29th, 2026, 9 a.m. or is your invite indicate? Bond continued. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Terrence Ginyard.
Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard. Your Honor, I'm just gonna hold the door open.
Okay.
Mr. Ginyard, can you please take your name for the record?
Terrence Michael D. Allen Ginyard.
And Your Honor, we're here for PCC today as well as the community corrections warrant. And I just want to first start off with the PCC. I am still working as fast as possible. I've talked to Mr. Cook about this case. He was just assigned to it after Mr. Overwater. So I am working to get a resolution as quick as possible on this. So I would be asking for adjournment for 2 weeks.
I'll adjourn the probable cause conference to 22nd,
As
2025, 9 a.m.
26, Your
The
Honor.
bond violation.
As to the bond violation, Your Honor, I did send into the court some a urinalysis as well as a lab that was taken for blood that goes back 2 weeks in response to the allegations that he was testing positive.
Where do you have that? Where do I get the indication that this test goes back 2 weeks?
May I approach, Your Honor? Okay, all right.
What I'm going to do, record to reflect to have bench conference in this case. Right now, he has a no bond bench warrant because of 2 tests. I've received other information that quite frankly isn't inconsistent with the testing because it could be low. His testing could indicate low or no use within the past 2 weeks. I will adjourn this matter out, set it to the 22nd. I'll adjourn it out 1 week to the 15th, 2026 at 9 a.m. At this point, however, the defendant's bond is revoked. I will indicate that based upon the request from counsel. Once I can get a straight story on this, then I will consider at that time his release on a scram tether as opposed to the sober. But at this time, defendant.
Right.
Letting you know that.
Your Honor, can I speak 1 second? I'll make it quick. So on here, I don't think what you did see, I know it says that the CDT result 1.4, It's consistent with low or no alcohol. But at the top, it says my current result in flag is 1.0, which means it's under the 1.4, which could be low or none. So my test is
I know how to read
1.0.
before.
Okay,
He did read it.
all right. That's all, sir. That's all I want.
And I also know, so that the record
Yes.
is clear, that on the sober link, on 2 occasions, you tested positive. And on the retest, continued to test positive.
Understood. That's why I pay for this test though.
I understand why you did it.
Yes.
But I'm saying, I'm telling you how this looks.
Understood.
All right?
Understood.
And the only reason I may consider release is because of the advocacy of your counsel. Because normally I wouldn't consider release. Normally what I would do is I just revoke your bond and you're gonna sit there.
Yes, sir.
But I'll bring you back in a week and we'll look at it again.
Yes, sir.
Thank you.
All right, thank you.
Thank you, Your Honor.
I just.
I got it.
Let them go back, okay?
You say.
I put it out, instead of 2 weeks, I put it out what? To the 15th. Yeah, it's a Thursday, the 15th.
At what time?
Well, I set it all at 9. It'll go into a block. You can talk to his attorney. They'll figure it out. Okay? You're welcome. Court calls the case People versus Devon Reed.
Brian Bowling on behalf of Mr. Reed, Your Honor. Devon.
Devon Reed.
Judge,
Yeah.
I'm asking for an adjournment if I could. So that I think we've got the issue with respect to the video discovery ironed out with Mr. Chavalowski. So I just
You
need,
have it ironed out.
I believe.
Get it? Okay.
Yes.
All right. January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you.
Thank you, sir.
Court calls the. Yeah, refusing. Court calls the case People versus Stephen Giffen. Gavon. People. Given, yes. He's refusing to come up.
He refused to speak with me as well, Your Honor. I do have a green sheet for his behalf, on his behalf. The prosecutor and I have discussed this case, not to a point of resolution, but we are trying to figure out the next steps.
This is set for confidential review.
Your Honor, it's my understanding that he has as of yet not spoken with them. He's refusing
right.
to speak with anyone.
All right, then I'll adjourn it out. See what you guys can come up with. They're out February 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
I like it.
Court does call the case of the People versus, this is Donovan. Too bad. Oh, there he is. Donovan Smith. Well, they got
Good afternoon, Robert J. Kill on behalf of Mr. Donovan Smith. Donovan, would you state your name for the record?
Donovan Smith.
Okay. So here's what I'm gonna do, best I can try to come up with. Is he gonna want exams on these? Is that the deal? Or what?
Oh, especially the CCW.
All right, that's
Yeah.
fine.
Yes.
Fine. So I've got the paperwork. What I did is I took the one that they sent back. You got the CCW here. Are both going to be requested for exam? So what I did is that rather than wait till next week, I got the paperwork. We're going to deal with it. What we're going to do today.
Okay.
Okay. So I'm just not going to wait. So I'm asking, what do you want to do on both of these cases?
You want to go to have exams on these?
Is it both at one?
Huh?
Is it?
Let me just say this also. Because the one that was a waiver was assigned to me, it has to come back before me.
That's fine.
So if you set, oh, thank you. But so if it's set, my next date would be February 3rd. But given all of the circumstances it is, and again, I'm not sure why things are happening the way that they're happening. I'll give you a special date as soon as I possibly can to put it before me.
That's fine.
Okay, so do you want exams on these?
If not, let's start that.
Well, we can either wade back up to circuit court. Okay, well, then we need exams, Judge.
You want to?
Yes, my client would like to have exam.
And I think it's more important. Mr. Smith, you understand what I'm trying to do, right? Okay. So normally if I were setting today, it'd be the 20th, but I'm not on the 20th. What do we? On the 20th, I can, if the other courtrooms are empty.
Correct.
I can do that. Okay. All right. So I'll set it as though you're asked. So I'm taking a week's time. Okay, best I can do. So I will set the preliminary examination in person. I'll set it for January 20th, 2026. You want me to do 1? Yeah, let me put it at 1 p.m.
Judge, not to cause any problems, I have a full docket with Judge Kunke that day. Is there any chance?
Well, she could have kept this one and you could have been on it. I'm sorry.
Is there any
Shouldn't have
chance we
said
could do that in
sweepingly.
the
Go ahead, what?
Is there any chance we could do it in the morning of the 20th?
No, because what's happening, the other judges are in my courtroom.
Okay.
And that's the best I can, are you gonna be there all day on the 20th?
I have 4 cases, yeah. Sentencings and show causes.
Give me another date, but it's gonna have to be before the 20th. I'm not gonna have it.
Okay, so we could do the 14th, Wednesday, the 14th.
At 3?
Oh,
Yes.
I like to go home.
You want for the 20th, yes, sir? Or you-
Right.
So it would have to be Wednesday, the 14th at 3 p.m.
Is the next time I have.
That's what my client wants, Judge. I'll know this afternoon if I'm going to trial on the 12th, but let's just schedule it for the 14th.
All right, we'll set it for, then I'll set it for the 14th. Pardon? I have prelims on the 13th? Well, what the hell? I mean, heck. Wait, what did you- My apologies for that. Why didn't you just tell me? I thought I did. I'll just set it on my prelim docket. January 13th, 2026. That'll be at 9 a.m. What were you guys doing?
Judge, just for the record, I'm pretty sure if my trial goes, I'll have to.
What were you guys, what? I know, so. What?
Yeah, we can skip if I have to.
What were they doing? I told you, I didn't want him waiting. I had the 13th, no. I had to do this the last time they were up there. Stop talking. 9 a.m., that's before me. So we're gonna get you in before even the time that was set for the case coming back. Now, the issue regarding bond, and I'm trying to, I need to figure this out. At the time, on the case that went up and has now come back, I gave him a personal.
No, you gave 10% bond. He had
10%. Did he
50,000
post
cash
that?
surety. He was going to post it that day, but that day also the new case came in. That case has a $25,000 cash bond. So right now he has a $50,000, 10%, 25,000 cash. We were asking if the court would consider 10% on.
10%. So, right, I got you. So the, 10% on the 25,000 cash, we were asking if the court would consider 10% on. So the, 10% on the 25,000 cash, we were asking if the court would consider 10% on. So right, I know. So the, 10% on the 25,000 cash, we were asking if the court would consider 10% on. So the, 10% on the 25,000 cash, we were asking if the court would consider 10% on. So the, 10% on the 25,000 cash, we were asking if the court would consider 10% on. So the, 10% on the 25,000 cash, we were asking if the court would consider 10% on. So the, 10% on the 25,000 cash, we were asking if the court would consider 10% on. So the, 10% on the 25,000 cash, we were asking if the court would consider 10% on. So the, 10% on the 25,000 cash, we were asking if the court would consider 10% on. So the, 10% on the 25,000 cash, we were asking if the court would consider The one he was gonna post, he is still in a position to post that one, right? Is that, am I right?
50,000, yeah.
The 50, you could still post.
10,000. 10%.
At the time that the agreement was made, him waiving and reducing his bond, were the people aware of that other case?
Judge, I can tell you that I authorized the charge on the 19th. And put it in the play. I don't. We didn't get the money until the 29th.
30.
No. Here's what I'm asking. When,
Judge, for what?
I hate the days I'm talking French because nobody's understanding me. Listen, on the, when he waived up, what date did he waive up?
23rd.
23rd of
December.
December. And that's when the agreement was made to reduce his bond.
Yes.
Correct.
So then this other case is out there. And so based upon those dates, the people were aware of that other case when the agreement was made to reduce his bond.
Yes.
Good, that's all I need to know. So on his new case, the carrying a concealed weapon, he's gonna post on the other case. I'm gonna set that for preliminary examination. I'm just going through, making sure my paperwork's clear. 13th, 2026, 9 a.m. before me on that case. On the court's own motion, that way I'm doing it because I think it's fair. I'm gonna reduce his bond to a $25,000 personal recognizance bond.
It means that's a PR bond. If you don't show up to court, you'll report 25,000.
So if he can post the other one, he can post the other one, and we're gonna be back right where we're supposedly supposed to be. Except that you're not in circuit court, you're before me.
25 grand. Thank you very much for your consideration.
Got that?
Thank
Okay, we'll see you on the 13th. And if you get out, don't do anything stupid.
I'm not.
You hear me?
Yeah. I don't even live in Ipsy.
Well, you
I'm
gonna do
gonna come
something
back
stupid
down.
someplace else?
No.
I just said, don't do anything stupid. I don't care where you are. Got it?
Yeah.
Thank you. Am I? They are. Court recalls the case People versus Tanisha Aiken.
Good afternoon again, Your Honor. People.
So someone with an apple hearing on behalf of Ms. Akins is approaching now. Ms. Akins, will you state your name for the record?
Tanisha Aiken.
She's waving.
Yes, Judge, she is waiving. There is an agreement to HIDA on both files. Additionally, the 25 F2 1212 file, there is a misdemeanor offer if she is able to pay a portion of the restitution, but we'll do all that in circuit court. But the people are not objecting to HIDA.
All right. Ma'am, you're waiving your right to a preliminary examination.
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts in the two cases.
Your Honor, we acknowledge receipt of the information. My client would stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Both cases, pretrial will be set.
March 2nd at 1:30 for Judge Mood.
March 2nd, 2026, 1:30 before Judge Hamoud. Yeah. And we'll continue.
Okay, thank you, Judge.
Thank you. Court does call the case, People versus Randall Laird.
Good afternoon, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Randall Laird, it's a PD case.
This case was called.
I think it's Miss Apple.
Yes, sir. Can you hear me?
Yes, yeah, I got you, Mr. Laird. Thank you, sir. I got you. I'm looking for your attorney.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Laird.
All right, what are we doing on this case?
Your Honor, we are asking for an adjournment. I have a sheet here. We are missing the discovery, all the discovery on this case. I did reach out to the Attorney General regarding that.
Any objection to the adjournment?
No, Your Honor.
All right. Probable cause conference will be adjourned January 29th, 2026, 9 a.m. as your invite indicates. Bond will continue. All right, thank you. Thank you, Mr. Laird.
Thank you, sir.
That is for the AG or no?
One more.
She has the next case also. Okay, she does. Court does call the case, People versus Tiffany Peters.
Good afternoon, Your Honor. Assistant Attorney
Attorney
General.
General.
Thank you, Your
Take
Honor.
care. Court calls the case, People versus Maya Hughes.
Ms. Hughes, would you state your name for record?
would you state your name for record?
Maya Hughes.
Whatever other device you have.
Whatever
turn it
other
off.
device you have, turn it off.
Judge,
we doing?
I just got,
I just got this.
I'm asking for adjournment.
I'm asking for.
Neither. All right, go ahead. What?
I'm asking to adjourn this matter. I just got the discovery. I did forward it to Ms. Hughes, but I haven't had the pleasure of speaking to her about it. Is it possible to get the same day, the 29th? You being the considerate judge you are.
Didn't think that earlier.
I can't do the 29th. I have another court date the 29th.
At my client's pleasure, I will ask for another date.
Pardon?
I will ask for another date then, Judge.
February 5th, 2026, 9 a.m.
Thank you, Judge. Ms. Hughes, we'll talk.
Court calls case, People versus Yakub Farah.
On behalf of Mr. Barr, who's working out.
Well, my name is Jacob Farr.
Yeah, we can do it.
Okay, can you sign? Your Honor, I did discuss an offer that was extended for a waiver in this matter. Mr. Farah did wish to waive his right to preliminary exam, proceed to circuit court. He'll be entering a plea under HIDA and the dismissal of count 2, plea to count 1.
Here we go. Well, this Caro's wrong. I have account too. Anyway, it doesn't, I got it. All right, so you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing, proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of the information. My client, wait for reading, my client will stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
Second at 1:30 before Judge Hamud.
March 2nd, 2026, 1:30 before Judge Hamud.
Thank you.
Thank you.
Thank you. Bond will continue. It's gotta go. Court calls the case, People versus Jacob Pike.
Good afternoon, Your Honor. Randy Cook.
Assistant Public Defender Hannah Apple, Mr. Fike, approaching.
Your name?
Jacob Pike.
Take your hands out of your pockets. Yes, sir. What are we doing?
Your Honor, I believe that we will need an adjournment for Mr. Fike.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Fife. Mr. Fike, I'm sorry. Yeah, yes, I'd ask for the court for a brief adjournment in this matter. I need to go over some things with
I need
Mr.
a
Fike.
green sheet, January
Yes.
29th, 2026, 9 a.m. bond continued. Thank you. Right. Court calls the case, People State of Michigan versus Elder Vasquez Sanchez.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Vasquez Sanchez in his absence today. If counsel and I could very briefly approach, Your Honor.
If you're going to discuss the reason he's not here, I understand.
Okay, thank you, Judge.
So what do you wish for me to do? I can adjourn it out.
Give me a raise and dismissal. No, I think that's
Just adjourn it
appropriate.
out.
Figure it out.
And
Yeah.
then you guys can, okay. Probable cause conference will be adjourned to February 5th, 2026, 9 a.m. Bound continued.
Your Honor, both Mr. Vincent and myself are in a trial in a death case on Third Circuit that day. If we could do
So
any
there's
day.
some other judge that's going to be painfully,
Yeah,
they're going to have. the
for
paper-
days at a time too. I mean, if you want to send flowers, I'll tell
Both of
you.
you.
And Your Honor, if I may, we may not even need to come back on that.
Right.
Today, so, I think we can set it for that day, counsel. And I-
That's fine as well. We can always stip if we have to.
Okay, that took a lot longer. All right,
As always, Judge.
Thank
Thank you.
Court calls the case, People versus Jacob Halfaker.
Okay, well,
And good
Oh, there.
afternoon, Your Honor. Joseph Hall appearing for and on behalf of Mr. Halfaker, who's now standing to my right. Mr. Halfaker, if you could state your name for the record, please.
Jacob Halfaker.
Thank you.
And Your Honor, we're in active negotiation with Mr. Chebalowski. We've had some productive discussions and feel like there is a reason to request that the court adjourn for further negotiations.
29th be enough time for it.
I would think so.
yes.
Probable cause conference, January 29th, 2026, 9 a.m. Bound continued.
Thank you.
All right, thank you, Mr.
Thank you, Chief. Thank you very much, Your Honor.
Thank you. Court calls the case, People versus Brittany Fisher.
Okay, well, you know.
Veronica Glenn on behalf of Ms. Fisher, she should be on the Zoom.
Ms. Fisher? Oh, there she is. State your name.
Yes, I'm Brittany Fisher.
Thank you.
Your
All right, what
Your
did
Honor, we're requesting a adjournment on this matter.
Green sheet.
Thank you.
Probable cause conference in this case, January 29th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Ashley Floyd.
Good afternoon, Your Honor.
Assistant Public Defender Chelsea Virgils with and on behalf of Ashley Floyd, who appears via Zoom. Please unmute and state your name.
State your name.
Ashley Floyd.
Thank you.
Yes, sir.
I have a green sheet. We are asking to adjourn to receive media and continue our discussion.
Probable cause conference, February 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case of the People versus Alan Fife.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Fife, who's approaching Judge.
Your name, sir?
Alan Fife.
All right. You're requesting an adjournment in this one?
Yes, Your Honor. I believe Mr. Fife may be a good candidate for the Specialty Veterans Court.
Probable cause conference, February 5th, 2026, 9 a.m. Continue.
Thank you.
Thank you. Thank you, sir.
Thank you, Honor.
Court calls the case, People versus Aaron Grable.
Assistant Public Defender Jim Bellinger on behalf of Mr. Grable, who should be appearing via Zoom, Your Honor.
Grable? Oh, there he is. State your name.
Aaron Grable.
Thank you.
Your Honor, we are just asking for a brief adjournment. I anticipate that this is going to end in a nully. So we just need a couple weeks to figure the rest of that out.
January 29, 2026, 9 a.m. Bond continue.
Thank you.
All right, thank you, Mr. Grable.
Thank you.
Court calls case People versus Jesselyn Gray.
Andrew Thomas, appearing on behalf of the people.
Assistant Public Defender Don V. Leba on behalf of Ms. Gray, who appears via Zoom. Ms. Gray, could you please state your name, ma'am?
Jesselyn Gray.
Thank you.
And Your Honor, we'd like to please set this matter for preliminary examination. Discovery is complete.
People have their witnesses available the 20th.
That's fine.
Preliminary examination in person, January 20th, 2026, 9 a.m. That is in person before Judge Moore. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Edward Gross. Chelsea.
I don't know.
Mr. Gross, can you?
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Gross.
Mr. Gross, can you state your name, please, sir?
Hi, Edward Gross.
All right, thank you.
How are you doing, sir?
Huh?
How are you doing?
I'm doing great, thank you.
Good, good.
Okay. Your Honor, we're asking for an adjournment so that we can have some further discussions with our client.
Probable cause conference, January 29, 2026, 9 a.m. Bond continued. Thank you, Mr. Gross.
Thank you, sir.
Calls case People versus Suzette Hampton.
Yeah, Assistant Public Defender on behalf of Ms. Hampton, Your Honor.
Hello, state your name.
Suzette Hampton.
Thank you. What are we doing?
Your Honor, we'd ask the court to set a preliminary exam.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 20th.
Your best.
Preliminary examination in this matter will be set in person. January 20th, 2020, 9 a.m. For Judge Fresh Hour. Right here. Bond continue. Thank you. Court calls the case People versus Dustin Hufford.
Assistant Public Defender Chelsea Vergils with and on behalf of Dustin Hufford, please state your name.
Dustin Hubbard.
Your Honor, I have a green sheet for this one as well. We're just asking to adjourn so I can discuss things a bit more with Mr. Hufford.
January 29, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you.
I'll give you a call.
Court calls case People versus Roger Jacobs.
Assistant Public Defender Jay Ballinger on behalf of Mr. Jacobs, who approaches. Mr.
Good morning,
Jacobs.
Your Honor. Good morning. State your name.
Roger Jacobs.
What's that look for?
Huh?
What's that look for?
What look?
You were giving a look.
Because I was going to tell him my package was late.
You had to be here, that's why.
He's never heard that.
Oh, because you had to be here. Sorry, we inconvenienced a bunch of people, right? Okay.
Your Honor, my client was just made an offer. He'd like some time to take it, to consider it. So we're just asking for 2 weeks.
That's fine. January 29, 2026, 9 a.m. Whereas the invite indicates bond will continue. All right. Thank you, sir.
Thank you, sir.
Thank you, Your
Have a
Honor.
good day now.
Have a good day and drive safe.
Sure.
I want one of those blue trucks. I don't have to put anything in it. I'm just going to drive it around. Makes people happy. Court calls the case of People versus Adonis Johnson.
Michael Gaddy, Assistant Public Defender on behalf of Nicholas Johnson, who's approaching judge.
Your name?
Adonis Johnson.
All right.
Your Honor, I've had a chance to go over this matter with the prosecutor, with Mr. Johnson. We asked the court for a very brief adjournment to continue discussing this matter. There's also some body cam I'd like to review it.
Oh, there's body cam, that's what.
Or if I wrote it, it might be Bubba. Okay.
Yeah, I don't know what, I was trying to figure out what that was, but I got it now. All right. Probable cause conference in this case, I'll adjourn this one to February 5th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
Court calls case People versus Anthony Johnson.
Good afternoon, Your Honor. For the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Johnson, who should be appearing via Zoom.
Mr. Johnson, Anthony Johnson, need to unmute, turn your camera on. State your name, sir.
Anthony Johnson.
Thank you.
Your Honor, I did submit a referral to our mitigation team to have a report completed. So if we could have a few weeks,
Okay.
I'd appreciate that.
Probable cause conference, February 5th, 2026, 9 a.m. Bond will continue.
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome, sir. Court calls case People versus Ethan Jordan.
Good afternoon, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Jordan, who approaches, Your Honor. And can you state your name?
Jordan.
And Your Honor, Mr. Jordan, we did stip to adjourn this off the record so that Mr. Jordan could hire U of M legal services for this matter. He has been able to do that. They were shut down during the holidays. They just need to do a substitution of attorney. So I'm just asking for 2 weeks so that they can get on this case.
Probable cause conference, 22nd, January 22nd, 2026, 9 a.m. Bond continued.
We set at 9 a.m. right now, but your attorney should be able to call the court the real time. Okay, all right. Just take care of the buck.
Court does call the case of People versus Kalisha Journey. Virginia's, where is she?
Assistant Public Defender Hannah Apple appearing on behalf of,
We're gonna cuff Virgil's to the podium.
what was that? Oh. Took a minute to process what you said. That's okay. Ms. Journey, can you state your name for the record?
Alicia Journey.
Yeah, so her last name on the file needs to be amended and on the complaint. And it's actually just her last name. Because we have it on the complaint as Journey. There should be an A after the E and before the Y. Is that right, ma'am?
Yes, sir.
All right. So is there any objection to the amendment of the complaint regarding her last name?
No, Your Honor.
Do that right now. Ugh, I can find it.
Thank you.
You're welcome. What are we doing on this case?
I have a green sheet, Your Honor. We're asking to adjourn so that Ms. Journey can review the media discovery.
For her media discovery?
Have it, she wants
You
to
have
keep
it.
it.
Got it. All right, then I will adjourn this one to the 29th of January. 2026, 9 a.m. Bond will continue. All
Thank
right.
you, Your Honor.
Thank you, ma'am.
Thank you.
Still trying to find my complaint. Court calls the case People versus Vincent Julian.
Good afternoon, Your Honor. Raymond.
Stephanie Can on behalf of Mr. Julian.
here? I don't have him on.
Your Honor, he would not be present by Zoom, at least not at this time. It is my belief and understanding that Mr. Julian is currently being housed at the McLean Jail in Minnesota with anticipated transport to a prison in Minnesota. So he would not be present by Zoom today.
Not said that way.
Oh,
Minnesota.
Minnesota.
Say it right.
So we are going to ask for an adjournment of this case to see if he can be with it here.
Probable cause conference, February 12th, 2026, night. Continued. I'll give you the adjournment rather than issue a bench. We'll start.
Thank you, Your Honor.
Calls the case, People versus Lamine Kaba.
Defendant Don Levo for Mr. Kaba, who appeared via Zoom. Mr. Kaba, could you state your name, sir?
Lamine Kaba.
Thank you.
And Your Honor, we're here for a competency hearing today. I'm not in receipt of a report from the Forensic Center. Senator,
I don't have a report either.
and Mr. Kaba has had his appointment.
He has?
Yes,
Okay. Then
and I do have a green sheet.
I'll adjourn this out.
Oh, I'm sorry, that was the wrong sheet.
Where I'm kind of putting these. I'll adjourn it out to February 26th. We may move the date up if we get the report before then.
Thank you, Your Honor.
February 26, 2026, 9 a.m. Bond will. Thank you, Mr. Kaba.
Thank you.
Call the case of the People versus Mohammed Kaba.
Stephanie Han on behalf of Mr. Cabo, who is approaching. Mr. Cabo, could you please state your name for the record?
Mohammed Kaba.
Thank you.
Your Honor, we're asking for an adjournment of this matter, just
sure.
if we can get some sort of negotiations going on.
January 29, 2026, 9 a.m. Bond continued. Thank you. Calls case of the People versus Tebby and Lewis.
Good afternoon, Your Honor.
Yeah, he's just a public defender on behalf of Mr. Lewis who's approaching.
Your name, sir?
Tavian Rules.
All right.
Your Honor, we're asking for an adjournment. There was there's some body cam. There was some problem with the sound. I was able to, troubleshoot my computer and fix it, but not in time for today's hearing.
January 29, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case People versus Diana Lewis.
And back on behalf of Mrs. Lewis and Zoom. Miss Lewis,
Vivian Lewis. Diana Lewis, excuse me. Diana Lewis. And
Your Honor, I'm asking to adjourn this matter.
okay. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you.
Calls case People versus Tricia Lopez.
Brian Bowling on behalf of Mr. Lopez, or Miss Lopez. excuse me.
Hi,
Speaking
Tricia
into the record.
Lopez.
Thank you.
Your Honor, I'm asking for an adjournment so I can review discovery by myself and with Ms. Lopez.
Probable cause conference, February 5th, 2025, 26, 9 a.m. Bond continued.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Tina Mageria.
Good afternoon.
Brian Bowling on behalf of Ms. Magira.
Mageira.
I like his.
I was wondering whether to make G. Well, anyway, I did.
Tina McGear.
Judge, I'm asking that this matter be set for a preliminary examination. All discovery is complete.
And would the people have their witnesses available the 20th? Preliminary examination in this matter will be set in person January 20th, 2026, 9 a.m. before Judge Brescia. Bond will continue.
Thank you, Judge.
Court calls case of the people versus Khalid Mahmood, excuse me.
Assistant Public Defender Chelsea Virgil with and on behalf of Khalid Mahmood. Please state your name.
Khalid Mahmood.
Thank you.
I have a green sheet. We are asking to adjourn for media discovery.
Media discovery,
Yes, Your Honor.
29th, January 29th, 2026, 9 a.m. Bond continue.
Thank you, sir.
Guess in reference to this case, we'll call it in regard to the Mopkin matter. The defendant does not need to be present and is not present. I think Joy was.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of the respondent, defendant. I don't.
Yeah, yes, she would be a respondent. Your name, ma'am?
Sequoia Jones.
Ma'am, you know why I held you?
Yes,
Tell me what your thought is on why I did.
because I disrupted your courtroom.
Yeah, you disrupted the courtroom, and then when I asked you to come back, try to figure out what was going on with you, you just kept continuing to walk. Why'd you do that?
My mind was like blank. That's my first time seeing my mom since, and it was just like a lot. It was a little too much. It was my first time seeing my mom since this incident happened. And I was trying to ask the lawyer something. I was so focused on her answering my question. I couldn't even really like hear anything else. I was too upset. But I'm not using that as an excuse. I take accountability. I was wrong for that. But
Your mom's coming back in a week or two, right?
That's correct, Your Honor.
Huh?
That's correct, Your Honor.
So is it that you can't, in seeing all of that, can't keep yourself composed in the courtroom?
no, I thought it was an understanding before my mom got up here about mentioning her injuries, and nothing was mentioned about that.
Okay.
And that's what I was asking
Can I
her.
just say this?
Oh, okay.
You need to let the attorneys do their job. Okay?
Mhm.
You have an issue to the extent that they'll even talk to you. If you have an issue with that, then you deal with that outside of this courtroom. So should I banish you from coming into this courtroom again?
No,
You think you can conduct yourself?
yeah, yes,
Young lady, I'm gonna give you another chance. If you come back in here and act the way you did, I'm gonna guarantee you this. You'll be locked up like you are now, but I'm not letting you out. Are we clear?
yeah. I have no problem with that. I'm not a disrespectful person.
You're not what?
I said I have no problem with that. I'm not a disrespectful person. I wasn't raised
Oh,
that
you
way.
were today.
I was today, but I'm not.
Not only
every
to
day.
whoever you were talking to, but also to me, and I hadn't done anything to you. Right?
Mhm.
So just check yourself next time before you come in here. All right, we can release it. Let her go.
Thank you.
Thank you. Court is standing in recess, and I guess we'll come back and do our 2 o'clock block and on. Court does call the case People versus Roderick Miller.
Good afternoon, Your Honor.
Roderick Miller.
Thank you, Your Honor. Assistant Public Defender Davi Liba on behalf of Mr. Miller. Mr. Miller, are you present on Zoom? Your Honor, I have not been able to reach Mr. Miller.
Yes, that's a violation. Correction.
I have not been able to discuss that with him either, Your Honor.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case of the People versus Amante Moore.
Assistant Public Defender Jay Bellinger on behalf of Mr. Moore, who approaches. Come on, Joe. And put your hands on your pocket, okay? Say your name for the record.
Monte Moore.
Thank you. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle, that being the 1 year misdemeanor. Upon a successful plea to that count 2, count 1 would be dismissed. That is the court's there's a sentence agreement of HIDA. You did go through a sentencing judge.
Yes, I explained to him that he wouldn't be sentenced in front of you, Your Honor.
Because that box is not checked.
I apologize.
Make sure that that's checked on this.
Thank you.
That the people's understanding of the.
It is.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Monte Moore.
Moore, it's this court's understanding that you are going to be pleading guilty to the charge of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 district.
Yes, Your Honor.
Understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form or had one or caused one to be signed on your behalf?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights. If you are part of a trial, you understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes, sir.
All right, because you believe that you are indeed guilty?
Yes, sir.
October 5th, 2025, at the location of Panama Avenue near Dawn Avenue in Superior Township, Washtenaw County, State of Michigan, were you in a motor vehicle?
Yes, sir.
Was there a firearm in that motor? Did you have a firearm in that motor vehicle?
Yes, sir.
Where was it located?
Under my seat.
Okay. And was it loaded?
Yes, sir.
And do you have any authority whatsoever to carry a weapon in that fashion?
No, sir.
All right. Sir, I do have to advise you that between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, first, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation and or recommendation. You understand that?
Yes, sir.
Counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be January 20th,
Yes.
2026, 10 a.m. before Judge Barr. We'll continue.
Thank you very much, Your Honor. Appreciate it.
Court does call the case of the people versus David Najera.
Good afternoon, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Najera, who should be appearing via Zoom. I see him.
Yep, there he is. Sir, state your name.
David Najera.
All right.
Your Honor, we are very close to a resolution here. One of the complaining witnesses was on an extended leave from work due to medical reasons. My understanding is that those conversations are being had, so we should have a resolution by next PCC.
I'll adjourn up February 5th, 2026, 9 a.m. Bond continued.
Thank you very much.
All right, thank you. Thank you,
Your
sir.
Honor.
Case of the people versus Jared Prince.
Assistant Public Defender Hannah Apple appearing on behalf of the. Yeah.
State your name, sir.
Jared Prince.
All right. I have before me a plea form that indicates the defendant will be pleading guilty to two charges. The first is stated count two of use of a controlled substance, a 1-year offense, and also attempted possession of a loaded firearm in a motor vehicle, a 1-year offense. That being counts 2 and 3. Upon his successful plea to that charge, count 1 would be dismissed. There is a sentence agreement between the prosecutor and defendant of Haida, and he signed the sentencing judge waiver. That's the court's full understanding of the agreement.
Yes, Your Honor, that's correct.
Is that true on behalf of the people?
That's correct.
All right, very good. May I have him sworn?
Solemnly swear to affirm the testimony you're about to give, the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Jared Prince.
All right. Sir, it is this court's understanding you're going to plead guilty to 2 misdemeanor charges.
Yes.
First being the stated count 2 of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court cost. Do you understand that?
Yes.
Also, an added count 3 of attempted possession of a loaded firearm in a motor vehicle, which is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture to weapon or device. You understand that, sir? All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you'd be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right. Still wish to plead?
Yes, Your Honor.
All right. To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of attempted possession of a loaded firearm in a motor vehicle, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right, you signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
You understand you're giving up your right to appeal of rights.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yep.
And because you believe that you're guilty of these offenses?
Yes, Your Honor.
On the date of November 5th, 2024, at the location of 650 South Forest Street, City of Ann Arbor, Washtenaw County, State of Michigan, were you in a motor vehicle?
Yes, Your Honor.
Did you have a loaded firearm in that motor vehicle?
Yes, Your Honor.
Where was it located?
Center console.
Do you have any authority whatsoever to carry that weapon in that fashion?
No, Your Honor.
All right. And on that same date and at that same location, did you also have cocaine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
Did you know what you were using was cocaine?
Yes, Your Honor.
All right. Sir, if I accept your plea, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor. And have I complied with the court rule?
Defense is satisfied, Judge.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
At 8:30 before Judge Perry.
January 30th, 2026, 8:30 before Judge Perry. Bond will continue. Thank you, sir.
Thank you.
Court does call the case of the people versus Christopher Quinney.
Good afternoon, Your Honor.
Excuse me, Your Honor, Michael Gaddy, Assistant Public Defender on behalf of Mr. Quinney, who's, I believe here by Zoom, Judge.
Oh, there he is. Mr. Quinney, state your name, please, sir.
Yes, Christopher Quinney.
All right. You're seeking an adjournment.
Yes, Your Honor. Thank you for allowing Mr. Quinney to participate via Zoom. He is ill today. I'd ask the court to adjourn it briefly so I can discuss this matter further with him.
Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
All
We'll
right.
be in touch, Mr. Quinney.
Thank you, Mr.
All right.
Quinney. Feel better, please.
Welcome, sir. Thank you, Judge.
Court calls the case. People versus Caitlin Quinn.
Assistant Public Defender Davey Leave on behalf of Ms. Quinn. Ms. Quinn, can you tell the court your name?
Caitlin Quinn.
All right. Where are we on this?
Your Honor, we're going to be requesting an adjournment order to review the discovery. I can prepare a green sheet, and I am prepared to address the bond violation.
Yes, go ahead and address
Thank you.
bond.
So with regard to the bond violation, Ms. Quinn indicates to me that since her arraignment, she has not used fentanyl or cocaine. And the fentanyl, she indicates to me, has been sent out for a confirmatory test, and she believes it to be a false positive. With regard to the cocaine.
What, the cocaine?
With regard, no, the fentanyl, Your Honor. With regard to the cocaine.
What about the cocaine? Yeah.
Ms. Quinn indicates to me that she last used cocaine, she believes, on the 17th or on the 16th before she was placed on bond, and that she believes it's residual from her prior use.
Really?
That is what Ms. Quinn has indicated to me, Your Honor.
How much cocaine did she use?
She indicates to me that previously to being put on bond in this case that she was a fairly heavy cocaine user.
Okay.
Yeah.
But how much did she use on this 16th day?
Ms. Quinn?
You know, okay, before you answer, seriously, probably one of the worst things you can do with me is lie to me or have me think you're lying. And I really am not as stupid as you look. So with all of that, go ahead and say what you were going to say.
Your Honor, I used it before I was told that I had to start testing. I'm a single mom and I would not do anything to mess up this violation. I have a slow metabolism, I think, and I promise you I would not do anything to mess this up. I have a lot going on.
You have such a slow metabolism that it would stay in your system 2 to 3 times longer than it would a normal human being.
I thought it was.
Is that what you're telling me?
I thought it was 6 days and I researched it online and it said that it could take up to like, I don't know, like 14 something days. I would never violate this. And then on top of it, one of my other medications that I use has not been showing up on my drug test.
So what am I supposed to take from that?
Well, I just don't know I don't know why the fentanyl got happened. And so I can.
You don't know why the fentanyl happened?
No.
Really?
I'm not just over here doing fentanyl. I contested it, sir, Your Honor. I'm a single mom. My father's, I'm
The
the,
third time I know. Understand.
I'm
you're a
sorry.
single mom.
Yes. I would not do anything to mess this up, and I really would appreciate a chance to show and prove to you that I am better
Man,
than
you
that.
haven't had a clean test since you were arraigned.
I tested today.
You did?
Yes, I did.
Okay.
And I was going to ask, Your Honor, if the court would consider contacting community corrections to determine the results of today's
I
test.
don't know if they've completed the test. I don't know, given these, why would I rush it? Because I don't believe her.
I suppose, Your Honor, I would ask the court to consider giving Ms. Quinn the benefit of the doubt and therefore waiting for the test to come in.
So I would have to await another dirty test? I already have 3.
I understand where the court's coming from, Your Honor.
Well, here's the benefit of the doubt I'll give. If maybe she has a clean test next week or this week, then I'll consider that in terms of what her bond should be. So I'll adjourn this out only 1 week to the 15th. 9 a.m. But at this point, given what I see here, if you want a hearing on that bond violation?
Your Honor, could I confer with my client about that?
Pardon?
Could I confer with my client about that?
Sure.
So we can have a formal hearing to contest the violation. We would have to have expert testimony, and I think in all likelihood it would not wind up being in your favor, so I don't think we should hold it.
What is it?
I think we should just defer that decision until the next test.
Okay.
Your Honor, I'd like to defer that decision until we have today's test results.
Till what?
I would like to defer that decision until we have today's test results.
Oh, okay. So the 15th, 2026, 9 a.m. Defendant's bond at this point, given what I see, I'm revoking the defendant's bond, defendant remains.
Thank you, Your Honor.
Court calls case of the People versus Lawrence Ransom.
Good afternoon, Your Honor.
Brian Bowling on behalf of Mr. Ransom. Your Honor, I have a green sheet. May I approach?
Yes, you may. Your name, sir?
Lawrence Ransom.
Thank you.
Your Honor, as the green sheet indicates, I'm just seeking an adjournment for additional plea discussions in this matter.
Probable cause conference will be adjourned to January 29, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you, sir. Court does call the case of the people versus Rayvon Reed.
Mr. Reed, who's approaching now. Mr. Reed, will you state your name for the record?
Rayvon Reed.
Thank you.
All right,
Your Honor,
there's some video discovered.
Yeah, one body worn camera that we are trying to track down.
Okay. Probable cause conference, February 5th, 2026, 9 a.m. Bond will continue.
Thank you.
All right, thank you. Take your hat off before, thank you. Court calls the case, people versus Jacob Sims.
Good afternoon, Your Honor. Robert Elman with it on behalf of Mr. Sims. Can you please state your name for the record?
Jacob Sims.
Your Honor, I've been newly appointed on this matter, so just asking for an adjournment for some time to get discovery and
Everything.
yes.
Probable cause conference, January 29, 2026, 9 a.m.
Thank you.
Bond will continue.
Well, set for the help. You soon.
Case, people versus Ty Smith.
Good afternoon, Your Honor. Raymond Cook.
Good afternoon again, Your Honor. Robert Elman on behalf of Taj Smith, who should be present over Zoom.
Can you see me?
Your name?
Tosh Smith.
Thank you.
Your Honor, similar to my last case, I was just appointed to this matter and I'd be asking for an adjournment.
Probable cause conference, January 29, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
Thank you, ma'am. Court calls the case of the people versus Ellen Reinhackle.
Correct. People. Public Defender Jay Valentine on behalf of Mr. Ryan.
All right, I have with me a plea sheet that indicates that the defendant will be pleading guilty to the charge of attempted fleeing and eluding fourth degree. That is a misdemeanor punishable by up to 1 year incarceration, a $250 fine plus court cost. Upon his successful plea to that charge, count one would be dismissed, and he has executed the sentencing judgment.
Correct, and that box is checked this time, Your Honor.
Yes, it is. All right. That's the court's full understanding. Is that the people's understanding?
Yes. Our understanding as well, Your Honor.
All right. May I have it?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Yeah,
I do.
State your name, please.
Alan Reinhackle.
Sir, this is court's understanding that you're going to plead guilty to the charge of attempted fleeing and eluding fourth degree. That is a misdemeanor punishable by up to 1 year incarceration, a $250 fine plus court costs. And that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had one signed on your behalf?
This, right?
Yes,
You went over that last time.
Yeah.
Yep.
Any questions regarding those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Sure.
On October 29, 2024, at the location of Tyler Road and McCartney Avenue in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
And you came into contact somehow or another with police. What happened during that whole thing?
I was coming down McKinley from Grove and Washtenaw County Sheriff got behind me. I knew it was the cops and then I drove away. I didn't stop.
Why were they trying to stop you? Did they tell you?
No. And, this guy behind me and
He got behind you,
My-
lights,
my-
sirens?
yeah. My plates were not good,
There you go.
expired.
Okay,
you know, like-
and so you knew, take your hands out of your
Oh, sorry.
pockets, and you knew that they were going to
Arrest
pull
me.
you over, right? And potentially arrest you.
Yes,
They had lights and sirens on,
yes, yeah.
and rather than pull over, you drove away.
Yes.
And you continued to drive away.
Yes, yeah.
And they had to pursue you in order to ultimately arrest you.
Yes.
So that really didn't work out for me.
No, I turned myself in.
What?
I turned myself in actually, but
It didn't work out for him. Your
Yeah,
Honor.
it's-
It did not work out for him.
sorry, I'm a little nervous.
No, so am I. Don't worry about it. All right. Sir, if I accept your plea, right, then between the time of my acceptance for your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled, nor would the court be bound by any sentence evaluation or recommendation, and you would not be able to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
Have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 12th at 10 a.m. before Judge Washington.
February 12th, 2026. What time? 10 a.m.?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you very much, Your Honor.
Thank you, sir.